Hello, everyone. It's Mr. Murphy again. I am reporting to you now from the uh, uh, rotunda of the National Archives and Records Administration building in Washington, D.C. Behind me are the Charters of Freedom. Again, would have been one of our stops, and I'm doing my best to visit each site that we normally would otherwise visit, but also link it back to whatever I'm discussing in review. So today we're reviewing civil liberties, source of many of those from the Bill of Rights. So the original copy of the Bill of Rights is located right here in the rotunda with the Charters of Freedom exhibit. So we are looking at moving into Unit 3. Unit 3 covers our civil liberties and civil rights. This review is about just an introduction of civil liberties. We're going to look at some of the key liberties we've talked about that appear in the Bill of Rights, in particular the First and the Second Amendments. We'll look at incorporation. And then note that the rest of the Bill of Rights will be addressed in more detail when we talk about due process and the rights of the accused and the application of many of those liberties. So with that, I'm going to share my screen with you and start our presentation. So you have our conceptions of liberty as the foundation for the Bill of Rights. It's how Americans, in terms of our political culture, understand and interpret the rights that are associated with citizenship. And it's not something that necessarily has always been with us as a people. Perhaps abstractly they have been, but the notion of civil liberties have changed over time considerably. So we all know that the revolution was inspired by many of these ideas of liberty, right? In fact, the radical group that led much of the resistance against Great Britain was known as the Sons of Liberty. And some of these ideas are articulated in the Declaration of Independence. The Declaration of Independence is a document that is rooted in this notion that there are natural, unalienable rights, right? That life, liberty, and the pursuit of happiness. So that these rights and liberties are so intrinsic to who we are that no government can take them away, no government can give them to us. And one of the concerns that emerged, as we know, out of the Constitutional Convention was this fear that the federal government had way too much power and that there was a risk, a potential for the government to encroach upon some of those rights that had been articulated in the Declaration of Independence. And so part of the motivation for the Bill of Rights on the part of the Anti-Federalist was to create a way to protect the individuals from an excessive use of power on the part of the government. So the early Bill of Rights that we talk about will have impose restrictions on government actions, as we will see. Now, it's important to understand that there were reservations about having a Bill of Rights altogether, right? Remember, Alexander Hamilton pointed out that there was a risk of listing rights because then it could be inferred that the government was in the business of granting rights. And if a right wasn't listed, then you didn't have it. This is one of the reasons why the Bill of Rights are written in the way that they are, with the Congress shall make no law or Congress shall not, because again, they're prohibitive in that sense. It's going to change a little bit throughout our history as we add amendments and adjust to some of the historical realities that our country is facing. The other thing is what Madison referred to as parchment barriers, right? Meaning that, we can have a law, right? We can have a written guarantee of liberties, but those guarantees are only as effective as the willingness of the government and those in power to actually carry them out. And that's one of the reasons why our judicial system is so important. And it's not always been there to ensure that these rights and guarantees are carried out, right? And there have been some bad Supreme Court decisions, and we've seen that, and we'll look at some examples of those. But that's the point that Madison is making. So what do we mean by civil liberties? They are simply personal freedoms that are protected from arbitrary governmental interference or deprivation, right? They cannot be taken away because they are intrinsic, they are inherent, they are inalienable, as Jefferson wrote in the Declaration of Independence. So let's look at how do we balance these liberties, because one of the important things that we've discussed is that liberties and the protections granted in the Constitution are by no means absolute, right? Freedom of speech, as we will see, for example, does not mean that you have the freedom to say whatever you want to, okay? Many decisions about how these rights are exercised and enforced or carried out or protected relate to this idea of the public interest. This is one of the things we started talking about at the very beginning of this class, right? When we had the discussion about the need for some type of government, right? The whole Hobbesian notion that people are born free, but everywhere they're in chains, that it's not possible for everyone to be free, because if everyone is free, then nobody is free. It's the extending one's arm example that I gave you. Remember, the right to extend one's arm ends where the other person's nose begins. Okay, so my expression of my rights cannot or should not interfere with your expression of your rights, because in that way, your rights would be being denied to you. Okay. This is particularly relevant to our current context because we have people protesting and making a fuss about COVID-19 and the actions that the government has taken or have not taken as it relates to COVID-19, the restrictions on businesses and on travel, so forth and so on. But this is where the public interest matter comes into play, right? The notion that these rights aren't absolute. At the same time, there is a responsibility on the part of the government to ensure the general welfare, right? Promote the public interest. So this is why it's this important balancing act. At what point, right, do my rights end when it could jeopardize the health, safety, or welfare of a fellow citizen? This is a handy dandy chart, and I'll put this in Google Classroom of kind of previewing the Bill of Rights. Some of the key highlights, we will focus on those relating to the rights of the accused in our next review when we talk about, as we move through Unit 3. Our focus today will primarily be on the First and a little bit of the Second Amendment, but these are the agreed upon rights that the framers of the Constitution negotiated essentially with those who insisted on having a Bill of Rights. They were considered the rights most at risk of being jeopardized by a larger, more powerful central government. Which brings us to our First Amendment, which has the 5 core freedoms, right? So we have freedom of religion, speech, press, assembly, and petition. So under religion is the free exercise clause and the establishment clause. So the notion that Congress can make no law prohibiting or inhibiting the free exercise of religion, which is more of an individual right, and then the prevention, blocking Congress from taking action that relates to the establishment of religion, that shows a preference for religion. And so we'll look at each of these in its own right. So the free exercise clause again, as I said, it prohibits the government from implementing laws that prevent the free exercise of religion, right? So again, these are prohibitive, right? They tell us what the government cannot do because the government is not in a position to give us rights. So the Constitution, because our government is sovereign, a sovereign power has the ability to limit its power. So these rights articulated in the Bill of Rights impose limits on the government's power. Remember, I drew the example of a pin, a fence. That's what these do. One of the required Supreme Court cases relating to this is the case of Wisconsin v. Yoder, and we talked about many examples of these, but for the purposes of our review, I'm going to highlight the required cases for the College Board. Wisconsin v. Yoder, that was the Amish case, the case of the Amish family that chose to stop sending their children to a public school. The question at hand was, were compulsory education laws that required even Amish families to send their children to school a violation of the Free Exercise Clause, right? Did it stand in the way of the Amish family exercising their faith tradition? And the court determined that yes, it did, right? So the government cannot establish a barrier to the free exercise of religion. The Establishment Clause is related to that, but what it does is prohibit the government from creating laws preferencing a particular religion or a lack of religion. And this is informed by Thomas Jefferson's letter to the Danbury Baptists, which we read, that talked about a wall of separation between church and state. And these two clauses, these two parts of the First Amendment were important to the Founding Fathers because remember, or to the framers, I should say, because remember, England had a state church, right? The king was the defender of the faith. The king was the head of the Church of England. So they did not want that type of intermingling between government and religion. The Supreme Court has developed a test called the Lemon Test that came out of the Lemon v. Kurtzman case to determine when a particular action by the government violates the Establishment Clause. And the Lemon Test has three parts. Is the purpose of the law or action religious or non-secular? Is the primary effect of the law to promote or inhibit a particular set of religious beliefs? And then three, does the law create an entanglement between government and religion? If it answers yes to any of those questions, then it is a violation of the Establishment Clause and it is unconstitutional, okay? Our required case relating to the Establishment Clause is the Engel v. Vitale case, 1962, which dealt with prayer in school. That was where the Supreme Court ruled that allowing for a school-sanctioned prayer was indeed a violation of the Establishment Clause because the school authorized the saying of the prayer. The school was providing a platform for the prayer, and it violated the Lemon Test in that it's essentially, it does have a religious purpose, right? It was promoting a faith tradition that relies on prayer, and then it creates that entanglement because the public school is a government entity. The Free Speech Clause, moving on, which gets quite a bit of attention as part of the First Amendment, prohibits the government from imposing unreasonable restrictions on expression. Now, there are exceptions to that, right? And it goes back to that public interest part. The common example we give is you can't yell fire in a crowded theater because then you're endangering the lives of others, okay? So the Supreme Court defined this clear and present danger exception in Schenck versus U.S. in 1919. Now, this was a wartime Supreme Court decision showing that the Supreme Court is not fully insulated from what's going on in society around it. But this was the anarchist, if you remember, where they were promoting a anti-government rhetoric in a time of war. The Supreme Court determined that that posed a clear and present danger and it could be limited. And that limitation has remained in place, although what we consider a clear and present danger has changed over time. Um, the protest and symbolic speech, again, that is something that has ebbed and flowed. We have seen many examples of that. We've talked about many examples of that in class. We've talked about the case of burning a draft card, which is a symbolic form of protest. But at the same time, it's the court at that time determined that it posed a danger, because if everyone refused the draft, then that jeopardized the country's ability to fight a war. The seminal moment for symbolic speech, though, came in 1969 with the Tinker v. Des Moines decision. That was is a required Supreme Court case. That was the case where the school children wore black armbands protesting the Vietnam War to school, and they were suspended for doing that. And they were not being disruptive. It was a peaceful form of protest, and the Supreme Court said that that was a protected form of expression under the First Amendment's free speech clause. More recently and more controversially, we have the notion that money is speech, right? That restrictions on political spending, restrictions on campaign spending are a violation of the First Amendment. That is something that the Supreme Court determined in 2010 in a 5-4 decision in Citizens United versus FEC, where they determined that restrictions on how much money could be spent to influence elections violated, believe it or not, the First Amendment, because it was a form of expression, of sharing one's political beliefs, opinions, and ideas. Now, like these other rights we've talked about, the freedom of speech is not absolute. Obscene speech is not protected by the First Amendment. Now, that then lends itself to the question, well, what is obscene speech? Leave it to the Supreme Court to come up with another test to tell us that, and that's the Miller test out of the Miller v. California case. So there are 3 components to the Miller test. The average person applying contemporary community standards finds that it appeals to the prurient interest, right? That it's sexual in nature in some way, and that's the what it's designed to appeal to. 2, it depicts or describes in a patently offensive way sexual and or excretory conduct defined by state law. That explains itself. And then 3, taken as a whole, it lacks serious literary, artistic, political, or scientific value. So it needs to tick off all 3 boxes of the Miller test in order to be considered obscene. And if it is obscene, then it's not protected by the First Amendment, and restrictions can be placed on it. Now, obscene, this is one of the reasons why we needed a definition or a test for this. Is, remember the Cohen v. California case where they involving the jacket that said, if the draft stopped the war. The Supreme Court determined there that one man's vulgarity is another man's lyric. So there's this fine line. Just because something's vulgar doesn't necessarily mean it is obscene, right? And so those kinds of things can be protected under the First Amendment. Related to free speech, and oftentimes students get these 2 clauses mixed up, but related to speech and expression is the free press clause, right? And essentially, the free press clause bans, protects the media or members of the press or folks who are trying to share information about what's going on from prior restraint. Prior restraint is basically stopping or preventing something from being published or printed or said before it's actually said, right? So under the New York Times versus U.S. ruling, this was related to the Pentagon Papers that exposed some government shenanigans that were going on during the Vietnam War. The Supreme Court ruled that the free speech clause protects against prior restraint. It does not protect against libel and slander, though, right? So this is saying patently false, defamatory statements against someone, either in a written word, that's libel, or a spoken word, that's slander. Now, if you are a news organization or a journalist acting in good faith, it's very difficult to challenge or to accuse you of libel or slander, right? You have to show malintent. There has to be malice, right? You had to have acted intentionally in a negative manner. Remember, I often tell you the best defense against libel and slander is the truth. If something is true, then you've just spoken the truth. Um, Also, if you're a public official, the standard is much higher. The burden, in fact, is on you to prove malintent on the part of someone you're accusing of libel and slander. The logic being that you're not required to be a public official. You're not required to put yourself out there, but by doing that, by taking that step, then you have to assume the liability of that. This also includes, not although not explicitly, it's implicit, is the protection of sources. It's very important in terms of journalistic integrity that a journalist can't necessarily be compelled to reveal their sources unless under just absolutely extraordinary circumstances. And then finally, we have the right to assembly and the right to petition. So you have peaceable assemble. Okay, so this does not mean that you can start a riot. Okay, this does not mean that you can threaten violence if you do not get your political way. But this, again, is important to think about the history of our country and the importance of organizing, the importance of protesting. Think about some of the early uh, protest movements, again organized by the Sons of Liberty that I referenced earlier. Think about what was happening before the Boston Massacre. Think about the Boston Tea Party. So debatable on whether or not the Tea Party was peaceful, but um, these are some of the examples that we're talking about. Um, and the idea was that, look, if we're going to have a representative system of government, the people need to be able to contact their representatives. That's the petition part, right? You can ask representatives and the people who serve you in government to act in a certain way. And that is why it's included as part of this First Amendment, because how can you adequately be represented if you don't have the right to contact your representative officials, or if you don't have the right to organize and assemble peacefully so that your government knows your views and how you feel about certain issues. This ensures adequate representation. And we also talked about the NAACP versus Alabama case, where along with the right to association and assembly comes this right to anonymity within those associations. Again, the exception, though, is unless there's a compelling government interest. And when we talk about due process and rights of the accused next, later on, we'll talk about some of those exceptions. Also, we're going to touch on the Second Amendment here. Second Amendment begins with a well-regulated militia being necessary for the security of a free state. Then it goes on to say the right of the people to keep and bear arms shall not be infringed. So the original intent behind the Second Amendment was this idea that we didn't have a standing army to speak of. We relied on state militias, and the nature of militias required citizens to keep their own armaments. And this also harkens back to the history of the British soldiers seizing the arms of colonists during the colonial era. So the motivation or the incentive behind the Second Amendment was for these concerns. Second Amendment, though, has kind of taken on a life of its own, largely due to the influence of organizations like the NRA, the National Rifle Association, that have funneled millions and over time billions of dollars into political campaigns. So much so that really the seminal moment for Second Amendment activists came in 2008 with the Supreme Court decision, District of Columbia v. Heller, where basically the Supreme Court read, and this is not one of your required cases, but I do think it's important for the context. the Supreme Court read into the Second Amendment in Heller a right to self-defense. So essentially, they looked at the Second Amendment and said, well, what's implied here in the militia language is that a constitutionally protected right to self-defense. And that's made it very difficult to enact many of the regulations on firearms that we've talked about in the recent political discourse. This became even more challenging because you have these federalism issues where, okay, if the federal government is prohibited from enacting laws restricting firearms, and in the DC case, right, DC is a federal district, so it's treated a little bit differently from the states. Congress has jurisdiction over Washington, DC. So localities, states and cities thought, okay, well, how about we can take action to limit firearms for the protection of our own citizens? Well, that became much more difficult in 2010, and this is a required case in McDonald v. Chicago, which extended those Second Amendment protections and the understanding of the Second Amendment as protecting self-defense to state and local communities. So it overturned some restrictions that Chicago had in place on firearms, which is a good segue into the doctrine of incorporation, right? So remember, in the beginning, the Bill of Rights only applied to the federal government. This was one of the concerns of the Anti-Federalists. They wanted very vehemently, one of the reasons why they were afraid to move away from the Articles of Confederation, they did not want to encroach upon state power and authority. You know, Thomas Jefferson is the author of the Kentucky and Virginia resolutions, which essentially outlines an avenue for states to nullify federal laws, which will later on become an issue just before the Civil War with the nullification crisis. So it became apparent, though, over time that this was not a tenable solution. So the notion of incorporation extends civil liberty protections to the state level. And this is one of the goals of the 14th Amendment, which was passed as a part of Reconstruction. So the 14th Amendment is critical because it defines citizenship as all persons born or naturalized in the United States. So irrespective of which state you're in, if you are born or naturalized, you are a citizen of the United States, and you are entitled to the rights and privileges of citizenship as a result, right? And you cannot be, as a citizen, your rights cannot be denied without due process of law. And we'll talk more about due process later on. Due process is also set up in the Fifth Amendment, but that's more or less relating to criminal proceedings. So the 14th Amendment is kind of the avenue, is the tool with which the Supreme Court can apply this doctrine of incorporation. Now, as we know, the court cannot engage in hypotheticals, okay? So this is what we mean by selective incorporation. A court can only incorporate parts of the Bill of Rights as the cases come to them. So there are some Bill of Rights that have not yet been incorporated legally just because a case hasn't come before the court to provide that avenue, right? But we can assume and infer that based upon the court's interpretation of the 14th Amendment, that all of the rights, all of the barriers and restrictions that are imposed on the federal government in terms of the rights of citizens are also imposed on state governments. The first example of incorporation, this is not a required case, but I'm just an FYI thing, is a case called Gitlow v. New York in 1925, which incorporated the First Amendment. Interestingly enough, it didn't say that the First Amendment was being violated, but it did extend that standard to the state level. Very important shift in our country's history, because even in the aftermath of the Civil War during Reconstruction, the Supreme Court did not take a broad interpretation of the 14th Amendment. If anything, it used the 14th Amendment to protect the states. I mean, think about the slaughterhouse cases, right? Or to pass rulings that benefited corporations and trust. So this is an important reminder that just writing something in the Constitution doesn't make it so, right? This is what Madison meant by parchment barriers. It's all in how it is carried out, how it is implied, and how it is interpreted by the courts and the different layers of government that we've discussed. So that is our overview of civil liberties. Just again, some of the rights articulated or the liberties articulated in the First Amendment and the Second Amendment, how they've been interpreted by the courts, hitting on some of our key required Supreme Court cases. And then in our next step of the review, what we're going to discuss is due process, rights of the accused, and more some of these more specific rights and some of the nuance involved in them and the way that the courts have interpreted them over time. So if you have any questions, as always, reach out and let me know. But hopefully this provided a substantial review for you of just where we are in terms of the Bill of Rights and how they've been applied in this context. Take care.